All right, let's jump straight into this explainer and really break down exactly who works for whom in a Rhode Island real estate transaction. Because let's be real, if you've ever bought, sold, or even just rented a property in the state, you've definitely had one of those dense, multi-page legal documents slid across the table to you. It's the Rhode Island Mandatory Real Estate Relationship Disclosure Form. And today, we're going to totally decode this thing. We're sticking strictly to the facts right off the form itself, so by the end of this, you're going to know exactly where you stand.
So, who exactly is fighting for your best interests? Now, what's kind of crazy about this question is that most of us just naturally assume an agent is automatically in our corner. You meet a friendly agent at an open house, you hit it off, have a great chat, and boom, you just assume they're your advocate. But under Rhode Island law, well, assuming that without actually checking the paperwork can be a really costly mistake. Let's look at how we're going to unpack this. Here's our quick roadmap. 1. The mandatory Rhode Island disclosure. 2. Understanding the 4 roles. 3. Comparing duties and confidentiality. And finally, 4. Mandatory disclosures and rights. Let's get into it. Okay, Section 1, the mandatory Rhode Island disclosure, and exactly why this form even exists in the first place.
I want you to read that quote really carefully. The absolutely crucial point here is the legal default. An agent literally does not represent you or your best interests unless you specifically agree to it in writing. It's wild, right? If you don't sign a designation, the state just automatically assigns you a default relationship, and that relationship comes with 0 fiduciary duties to you. Let's explore exactly what that default role and the other 3 options you have actually look like in the real world. Moving right along to Section 2, understanding the 4 roles, so you can clearly navigate your options.
Okay, so this first role is our baseline, the transaction facilitator. They can assist you, they can perform basic agreed-upon administrative acts competently, and yes, they have to act with honesty and good faith. But here is the massive catch. They absolutely cannot negotiate on your behalf. Period. They simply do not represent you.
If you haven't signed anything at all, this is your scenario. You're in the default. The agent is just facilitating the transaction. Now, sure, they are legally required to properly account for any money or property placed in their care. But your financial secrets, yeah, those are not legally safe with them. They owe you absolutely no confidentiality and 0 fiduciary duties. So if you casually mention your maximum budget, they aren't legally bound to keep that a secret from the seller. Just let that sink in for a second.
Now we step up to the absolute highest level of protection, where the agent actually acts as your dedicated advocate, the designated client representative. Honestly, this is the role most people just assume they have when they start working with an agent. When you actively decide to be protected, you enter this advocacy scenario. As a designated client rep, the agent owes you their full fiduciary duties, meaning they have to promote your best interest in good faith and completely protect your confidential info both during the relationship and even after it ends. But remember, and I can't stress this enough, this requires your informed written consent on that form. Oh, and here's a really vital detail straight from the law. Only that specifically appointed licensee represents you. The other agents working at that exact same brokerage, they owe you no duty except for basic confidentiality. Which brings us to a much trickier definition. What happens when you really want to buy a house, but your own agent happens to be the one listing it? Well, that's when we enter the tricky territory of the neutral dual facilitator. I like to call this the balancing act scenario. Because the agent is stuck right in the middle of the deal, they completely lose their ability to advocate for either side. They have to remain strictly neutral regarding any conflicting interests between you and the seller. Now, they do protect the confidential info of both parties, and they still account for funds, but because they can no longer fight solely for your best interest, this scenario requires a completely separate, highly specific dual facilitator consent form that everyone involved has to sign. Our fourth and final role deals with the boss, the transaction coordinator. This is typically the principal broker, who acts as the primary overseer of the entire office. So, this scenario automatically kicks in when 2 different agents under the exact same broker represent opposing sides. Let's say Agent A represents you, the buyer, and Agent B represents the seller, but they both hang their license at the exact same brokerage firm. That creates an inherent conflict of interest, right? The law actually solves this by having the principal broker step back into a neutral supervisory role as the transaction coordinator. The broker doesn't owe fiduciary duties to anyone in the transaction anymore, just confidentiality and proper accounting of the money. And unlike those other roles we talked about, the broker becomes a coordinator completely automatically. You don't need to sign an extra disclosure form for this to happen.
All right, let's pull all of this together in Section 3, Comparing Duties and Confidentiality, using our master matrix. I absolutely love this breakdown because it brilliantly summarizes how these real-world scenarios dictate your legal protections. Just notice how your fiduciary duties and your confidentiality shift completely depending on the role. As a default transaction facilitator, you get zero fiduciary advocacy and no confidentiality. But if you choose the designated client rep scenario, you lock in full duties and guaranteed privacy. And crucially, look over at that disclosures column. Every single step up in your legal protection requires specific mandatory actions, from the agent presenting the form early on to your written consent to entirely separate agreements or even automatic triggers. It's all laid out right there. Let's wrap things up with Section 4, Mandatory Disclosures and Rights, the legal timeline. This timeline is absolutely critical for you to understand as a consumer. The agent is strictly required by law to present this disclosure form to you before you spill any sensitive financial secrets. If you start chatting about how high you're willing to go on a price before you've seen this paperwork, you are taking a massive risk. Furthermore, if you decide you actually want the licensee to represent you, that official relationship has to be established no later than the preparation of an offer to purchase, a purchase and sales agreement, or a lease. And here's a really quick but super vital detail. Modern real estate involves a lot of teams now. The Rhode Island form clearly states that if you're working with a real estate team, which means 2 or more licensees working under a designated team name, the law actually requires an extra addendum. You need to know exactly where every single person on that team stands regarding your representation. So, if you take only one thing away from this entire explainer, it should be this single fact. True advocacy requires your active, written permission. The law is literally designed to protect you, but only if you engage with it. If you just assume someone is acting as your designated client representative without actually signing the mandatory form, Rhode Island law presumes they are just a transaction facilitator who owes you absolutely no confidentiality. It's a really vital question to keep in the back of your mind, right? Knowing the distinct differences between a facilitator, a coordinator, and a designated client representative truly empowers you to navigate the real estate market with your eyes wide open. So always read the disclosure, understand your chosen role, and make sure you protect your best interests.